Cummings with,
Good, how are you?
Afternoon, everybody.
and
We got
then,
this,
school.
half of them was
Okay.
we've been having technical difficulties too.
The main
You gotta
part.
speak kind of loud
Yeah,
for
I
that,
think
for the
so.
people in the computer.
I don't know.
All right, is that loud enough?
That's perfect. So just to give you a lay of the land, that is the public Zoom. This is the JNC members. That's, there's no sound or anything. So that you might get some questions from this peanut gallery. If you do, go ahead and answer them. So my name is Andrew Morgan. I'm chair of the JNC. Welcome. Thank you. And can you tell us why you want to be a circuit court judge?
Certainly. And good afternoon, everybody. Thank you for the opportunity to be here. I'm Chris Kelly, and a current city county judge. And I've had an opportunity to serve almost 9 years now in that capacity. Had a lot of varied experience as a county judge, both in the civil dockets, criminal dockets. Time spent doing some injunction work as a permanent, temporary assignment along the way. But county really gives you a broad experience, because one moment you're under civil rules, then you're under small claims rules, then you're under traffic rules, and then you jump into the criminal rules. I've also been involved in a lot of different committees, associations, things like that. And I start with that, answer the question of why do I want to be a circuit judge? Because I think there's been a time where I've looked at it and said, I really like being a county judge, and I do, and there's still a lot of challenges, a lot of things to be done. But my career has been one where I seem to look for that next challenge. And I'm at that point in my career where, having had the opportunity to have the experience I've had, work with the colleagues I've had, sit in on some circuit work, that I feel it's time for that next challenge. So that's why I'm here today.
When you were in private practice, describe kind of your caseload for me.
In private practice, when I first started there, I was hired primarily to assist Larry Bartlett, was one of the partners there, with civil litigation. There's a lot of commercial litigation, just general civil practice, contracts, condo homeowners association foreclosures. I always describe the practice as easy to say what we didn't do, which is we didn't do family law and we didn't do personal injury. But beyond that, estate planning, again, commercial litigation, real estate. We did a little bit of everything in the business estate planning arena. And so I was hired to help Larry, and as things progressed and I soon became a partner there at the firm, I had the opportunity to kind of find what I wanted to do. And even though I continued doing a lot of condo homeowners association work, I drifted more into the estate planning area. And Kathy Crotty was a CPA, so Kathy had the true estate planning knowledge, and she did an awful lot of estate planning work, so I had an opportunity to learn a lot from her. And then Michael Crotty did a lot of our real estate, and so had an opportunity to learn a lot from him about the real estate. But as time went on, I really concentrated more on the condo homeowners and estate planning elder law area.
Do you have family law experience?
Doing injunction work, and it's the family law rules, but again, it's a very small part of family law. I've sat in once or twice to cover more so case management dockets for some of our circuit judges. There have been times, and I can't recall specifically, but I know there was a day where one of the judges unexpectedly didn't show and somebody needed to jump in and cover the docket, and so there were some family law hearings I handled. And in a lot of ways, that's why I started out with my experience as a county judge. And as a judge in general, sometimes you never know on the particular day what you're going to get thrown at you. And while I understand from my colleagues that I have close conversations with that we bounce things off of each other, that family law is probably more than a lot of areas, there are some very unique things to it. But I understand that and am prepared to do what I need to do to make sure I'm ready to tackle that if that's where I were to be assigned. I think think the understanding is right now that's where the opening is. But as we all know, that can change very rapidly, but I think that's a good presumption that it will be a family law docket.
What are your feelings on the death penalty?
Well, the law, in certain situations, directs that it be imposed. It's up to the state attorney to seek it. And as a judge, I take an oath to follow the law. And so if the state attorney seeks it, they were to prove up the necessary things they need to prove up for it to be imposed, and the jury were to come back, I would certainly be a consideration, and I would do what the law requires.
Is there an area of the law you're interested in, but the circuit's more adverse?
And I can't say necessarily that there's one particular area. I've enjoyed the opportunity. I think one of the things through my career is I think maybe I have an appetite for knowledge and to learn new things. And so I continually seek out those opportunities. And I've enjoyed my time in civil, I've enjoyed my time in criminal. And injunction work was interesting, but again, it was something that I enjoyed the challenge of becoming more effective and efficient in handling injunction work. So I can't say I really have one particular area that I am more interested in than another.
Judge, this is Charlene Matthews, and
Good.
please let me know if you have trouble hearing me. We've had glitches so far today. But have you had the opportunity to have to address and deal with pro se litigants? And how do you go about hearing the case and without helping them present their case?
And as a county judge, the county courts being where the high or percentage of cases people come to court for the first time in county court, and whether it be small claims, traffic court, evictions, I've seen a lot of self-represented litigants through the years, and with the understanding that self-represented don't get treated any differently, or the law doesn't apply any differently to them. My procedure has generally been to make sure up front that they understand how the proceedings are going to take place and what is going to be required of them. That I cannot be their attorney, I cannot advocate for them, that they need to make sure that they come in prepared to present their case. And in particular in small claims, when the case would get set for trial, I had kind of final words for them that I would tell them that when you come back for trial, be prepared for trial. As I said, one of the first questions you're probably going to ask me is, what do you want to see or what do you want to hear? And my answer to you is going to have to be, I can't answer that for you. So we've got a law library down the floor here. It actually does. It has a great book on how to present a case in small claims court. You need to be prepared to present their case. So my role as the judge was to make sure they understood the process, what the expectations were going to be of them, but once the trial really started, was that it was their case to present. You know, occasionally along the way there might be a prompt of, you've alleged this. Do you have any evidence or witnesses you wish to present in reference to that? But beyond that, that was the extent of what I felt my role was in helping self-represented litigants, even in small claims. Small claims rules are very clear. The judge cannot advocate for a litigant or even instruct them on accepted rules of law. We can help them with procedure and decorum, and that's really about it.
I have a question for you. You know, the appellate court defers to a judge to determine, you know, a lot of times that do we have somebody who's, you know, lying or not lying, you know, that the trial court makes those calls. What do you look at when you're put in that position? You're trying to figure out who's lying, who's telling the truth.
And I start off with, it's interesting in what I've done. Most of the times, a lot of times there hasn't really been a dispute over the facts. In small claims and traffic and what have you, there hasn't been a dispute. They want to argue over the nuances or what they think the result should be. Not so much the facts, but you know, some of it's real easy. one of the things I learned is that sometimes letting, particularly a self-represented litigant, go on, a lot of times they tell you themselves whether or not they're telling the truth. And that's true for almost any witness. The more questions that are asked, the more that story may change a little bit. So I think it's the detail in what they're telling. Sometimes it could be too detailed. Sometimes we all don't remember all the details, and when you remember too many details, that can be a tell that maybe they're not telling they're trying to put their facts in the best light, or make up facts that didn't really happen. Sometimes it's just the mannerisms. It's but people are generally nervous when they come to court, so I don't necessarily attribute that as somebody's not telling the truth. I think it's really more what they say, how they say it. Is it consistent with what they allege to begin with? Their testimony throughout. So each case really is different, and each person's different, because some people come in nervous, and so you don't necessarily hold that against them. Others are very confident, and sometimes too overconfident, and that can be a tell as well.
Can you think of a time where you think maybe you got it wrong? And if you can, what you did or how you learned from it?
There was a time very early on a motion for summary judgment where after the hearing, and it was based on technical admissions, that the attorney representing a corporation filed a motion for summary judgment, was filing based on technical admissions. It was a self-represented litigant, and the overall court file showed that there was a dispute over the facts. The attorney was relying strictly on the technical admissions because the self-represented had not responded. I denied the motion for summary judgment, and afterwards I thought, I got that wrong. And I actually set it for rehearing. And when they came in for rehearing, things unfolded a little bit more that the attorney actually knew at the time they asked for these technical admissions. He understood that there was a dispute over, it was alleged that the contract attached to the complaint was fraudulent. And they knew that. And so this case was being decided purely on the technicality, while there was case law that says that's not necessarily appropriate. You want to resolve cases on summary judgment if there truly is no disputed facts. But technical admissions where one party knows that the facts are disputed is just not appropriate. I got appealed and affirmed on appeal. But that was one where I thought I got it wrong, and I set it for rehearing with the idea that I'm going to reverse myself, but I want to explain why I'm doing this. And as the hearing unfolded and I heard more from both sides, I guess in the end I got it right. But if I felt I got something wrong, I would reverse myself. We have the ability to correct our own judgments if we believe it was an error, and so I would do that.
What do you see, Judge, as some of the challenges in being, at least based on what I read, you've been the administrator for the county court judges for several years. That's a different job, and so tell us a little bit about that and what you learned from that.
It is a different job, and one of the things about being the county administrative judge, and even you're selected by your peers and appointed by the chief judge to that role, and even the chief judge really has no supervisor authority, and the county administrative judge has even less. It's if there are issues, and usually as a county administrative judge, the chief judge asks you to address those. Sometimes you identify things yourself. The difficult part of it, I think, is that each judge is their own entity. We are all constitutionally elected officers, and we're all going to do things our own way, and in many ways that's a very good thing. But it can add to confusion for the litigants that appear before all of us when the procedures and the way somebody conducts their docket may not be what the attorneys that appear in front of them would expect to be, or expect is the norm. Probably most challenging thing during my tenure as county administrative judge was COVID. And I say that because we got shut down in March of last year, March of 2020. And as a county administrative judge, a big part of what we did was to try and help get things up and running. In my role, since I was on a civil docket at the time, particularly in the civil division, but also helping out within the criminal division. So for the most part, the county administrative judge, there's very few issues that come up that you had to deal with them. COVID, though, was a big ticket item.
What do you, speaking on that, what do you see the role of Zoom or what Microsoft Teams, whatever it is? How would you use that in your courtroom?
And I laugh a little only because we're having technical difficulties today. And, and that happens not infrequently. And so I have concerns about in what type of proceedings it's going to be used. Because if you're in the middle of a jury trial and Zoom goes down, what do you do? I know for the most part, we've gotten it to where it works pretty well. I look at it this way. We've been doing remote proceedings since I've been on the bench, and even long before that, but it was mostly called court call. I see Zoom playing a role there in replacing court call and probably expanding that. To what degree, I don't know. I know the intent is that largely be left up to the individual judges as to what role they believe it plays, and to have the discretion, in most cases, to say yes or no. In civil, it will likely be depending on the length of the hearing as to whether or not the judge has to show cause, why they're not going to allow it. I think it plays a role. My concern is that now sitting on a criminal bench, I find, from my personal experience, that getting cases resolved, and as judges we have a duty to manage caseloads and move them forward, that Zoom seems to be less efficient in resolving cases. If we can address some of those inefficiencies, I could see it maybe being more utilized in pretrial conferences and things like that, but at the present time I don't think we've addressed those inefficiencies. So it plays a role going forward, and as I said, we've been doing remote for a long time, and Zoom enhances what we've been doing, and I think expands what we're going to be able to do.
Do you think I did get some comfort in the fact that one of your references to Slayton was offset by Father Tyndale? So this seemed a good balance that you used.
Do we have any questions in the room? Any questions online? We made it with no technical difficulties.
All right.
How about that?
Trying to convince me that this remote thing is a great thing for everybody. Thank you, everybody.